Hello and welcome to Calm the Farm podcast, where pharmacy business meets legal wisdom, minus the headache. In each episode, we share practical legal tips and real-life examples to help you run your pharmacy with confidence. I'm your host, Sarah Stoddart. Thanks very much for joining us. Today on the podcast, I'm having a bit of a rant. And it's a rant that comes from a good place, and that is a place of trying to advance the interests of our clients when we are dealing with transactional matters. But when we are dealing on transactional matters that involve a pharmacy business, it means dealing with regulators at both federal and state level. Now, historically, dealing with the Department of Health at federal level has been fairly smooth sailing. However, of late, when we are having to provide more and more documentation as part of a change of ownership application, we do come across a number of challenges. And it's important for pharmacists involved in transactional matters to be aware of the challenges that are being faced so that you can prepare documentation accordingly, but also so that you can have realistic expectations around how long these transactions are actually taking. So if we take, for example, some recent Department of Health applications, we're getting pushback on lease documents mainly. Now, there's a number of issues that can come up in lease documents. Some of those, which I've spoken about previously, is the need for consistency between addresses. So your address on your application, the address on your lease, the address on any subsequent lease documents, and then, of course, the address on your consent documents need to all have the same address. We try where we can to get confirmation of the address if there isn't consistency from the landlord's solicitor, but that is not always possible. So this is why if your solicitor is on to you about ensuring consistency of address, shop numbers, street names, building names, etc., there is method to their madness, and that is because of the need for consistency. The department is picking up on these issues, and no longer are they just emailing us to say, hey, what's going on here? Can you clarify? They're actually knocking back the applications, returning them into the portal, which means that when the issue is then addressed by the solicitor or the applicant, it joins the end of the queue. So we're not holding our place in the queue anymore. So this is a significant issue. So there is a need, as I've banged on about before, to ensure that real consistency, particularly with your shop names, address, etc., between the documents. We're also finding that the department is having some difficulties interpreting transfers of leases, particularly where that transfer is for an interest in a lease rather than a whole of land transfer. So that is adding some difficulty. And again, if your solicitor is giving you documents like this to sign, it is important to give them priority and urgency. Turn them around, get them back to your solicitor, because these applications are taking longer and longer, and the sooner we can get them into the regulators, the better. More significantly at the moment are the challenges that we're experiencing with the state regulators. Now, of course, in Queensland, we still have Queensland Health as I speak, and the new council is expected to commence their work on regulatory applications from 1 November or thereabouts onwards. They all are already working hard on other matters, but our council formally commences then in terms of regulatory approval applications and pharmacy business licenses, etc. Now, in the southern states, we of course have Pharmacy Council of New South Wales and the Victorian Pharmacy Authority. We are getting ongoing issues with those regulators as well. So if you are in Victoria and transacting, please make sure your plans are correct and as detailed as they need to be. Look at the guidelines that the VPA puts out and ensure you are absolutely addressing all of those things, because we are experiencing them going through those checklists and guidelines with a fine-tooth comb, and they will stop applications from progressing if certain items are not addressed. When it comes to the Pharmacy Council, I think there's a lot of word in the industry about the challenges being experienced there. One thing we are finding is the council asking for items that are not detailed in their application forms. So the application form asks us to submit certain things. They're coming back asking for additional things. Now, I don't know about you, but my crystal ball is not that accurate such that I can predict what someone might ask for. So if you are finding you're in a transaction in New South Wales and your solicitor is coming back mid-transaction asking you for documentations that are required by the council, please be assured it is not your solicitor having overlooked something, but rather the council deciding to ask for something they may never have asked for previously. This is causing absolutely no end of frustration. It's also contributing to cost and timelines, and I'm just pulling my hair out, frankly, dealing with these sort of issues. The other thing we are finding across regulators at the moment is really honing in on trust deeds. So if you do have a trust involved in your structure, making sure, please, that it is compliant with the state in which the business is located. What is compliant in one state isn't necessarily compliant in another state. So make sure it's compliant, and please, I beg you, make sure you have advisors working on your matters that know pharmacy. It really does make a difference, and will pay off for you in the end. So that's my rant for today. I'm glad I got that out of my system. I feel better now. I can sigh and carry on. But the moral of this story and the moral of this episode is to convey to our listeners that pharmacy change of ownership applications are getting harder, not easier. More and more documentation is required, and more documents are being heavily scrutinised, which is causing costs, delays, headaches, you name it. It's there. But please work with your advisors, work with them early, and make sure you're getting documentation back to them as soon as possible. The other thing I would say is that whilst we know that our clients are eager to know whether the regulator has approved an application, if you're working with us, please be assured we will communicate with you as soon as we have information to convey about whether the state regulator or the Department of Health has progressed your application. If you don't hear from us, it means that we haven't heard. We are aware of it. We haven't forgotten about you. It's just that following up, unfortunately, isn't going to help. Sometimes the regulators just won't deal with follow-ups or give us information back that is unhelpful. So we have your best interests at heart. We are progressing as much as we can, but sometimes we are in the hands of regulators, and at the moment, that's not the most fun place to be. Not sure if that's helpful or if it's just me feeling better about current situations. If you have any questions, yell out. Thanks again for listening.